Okay, so my name is Christy Kozak. I'm a senior program manager here at TSPA. You likely know what TSPA is if you're here, but if this is your first experience, I'm just going to give a high-level intro and then we'll dive right in. TSPA is a nonprofit who's supporting the global community of people working in online trust and safety. We work alongside trust and safety teams to help them develop expertise, skills, and relationships that they need to navigate this very unique profession. We're also a space for the community to connect with each other and exchange ideas around how we do this work in trust and safety. So with that being said, this is a perfect example of when the community is coming together to say the DSA is here, now what? Which I think is a question everybody's been asking since this has been a long year, 2 years, 5 years of anticipation, what it feels like. So today we've teamed up with the lovely team at Tremau to talk about what platforms need to be aware of in 2024 now that the DSA is here, what that enforcement will look like, and who the regulators are. So with that, I'm going to turn it over to the team at Tremau. I'll be back at the end of the webinar to facilitate the Q&A.
Thank you so much, Christy. So I'm going to do quick intros now to our team, to the webinar here, and to our fantastic panelists. I'm really excited to get into the conversation. So the 17th of February came and went, and surprisingly, the sky did not fall on our heads. The DSA is live, and for the companies that have been sprinting to meet these deadlines, I do hope that you got a break, at least on Sunday. I am Agne Kaarlep, Head of Policy and Advisor at Tremau. We're a trust and safety company where we help other companies adjust their trust and safety operations to the changing regulatory landscape. And in our panel today, we're joined by 3 fantastic panelists. We have Julian, who is a project director at the non-for-profit think tank Stiftung Neue Verantwortung, or SNV for short. He analyzes approaches to platform regulation in the German, European, and transatlantic context and develops policy recommendations that can be used by political and civil society decision makers. We have Benôit Loutrel, who is a board member of ARCOM, the French audiovisual and digital media regulator, since 2021. He leads ARCOM's involvement in the implementation of the Digital Services Act, and previously he worked on digital transformation for an internal consultancy of the French government. He's also a former Director General of ARCEP, France's Electronic Communications and Postal Services regulator, and he previously spent 8 years at the World Bank infrastructure in infrastructure financing, and was briefly a public policy director for Google France for a few months in 2017. So dabbled in tech. And we have Athina Tsitsou, who is the deputy head of unit for platforms policy and enforcement at the European Commission's DG Connect. She has a legal background with studies in Greece, Belgium, and United Kingdom, covering a broad range of legal matters. And before joining the European Commission, she was working in a law firm in Greece. And in the European Commission, she also worked in DG Grow and DG Connect on various internal market areas. Before we go into the DSA discussion that we have here today, I wanted to just quickly show what will be waiting for us now that the DSA is live. Take a look at this more than 10 seconds. This can be a little bit intimidating to start with, but these are the various moments in time where we can await for new risk assessment reports or new transparency reports from either the previous 19 VLOPs that were designated first or the new 3 VLOPs that were designated now. We also have the DSA audits deadline coming up in August, and the general deadline for transparency report across all intermediary services. And I think in October as well, you can wait for things to actually be published on the first risk assessments and the first audit. So there is a lot to look out for in the coming year around DSA implementation. So when you were thinking, thank God this is over now, the DSA is here, I think it's just the beginning. And with that, I think let's really dive into discussion with our panelists. And maybe I'll turn to Julian first. there's been a lot of variation in views of how EU platform oversight might unfold. Could you address some of these views, fears, and perhaps give us some insight into your understanding?
Yes, happy to do that. Thanks for organizing this, and thanks for the discussion that's upcoming. I'm really curious myself to hear from the others. Yeah, I do think there are different views on what the DSA can bring. Sometimes I think these views are rather political and not necessarily based, arguably not necessarily based, but by what's in the DSA. So if you read some politician statements or parliamentary debates or press releases. So I think what we've seen sometimes on the one hand, there's people who have very high hopes, very high expectations that the DSA will basically clean up the internet and we won't have any more hate speech. And on the other side, the other extreme is you have fears that the DSA will actually make the internet too clean, right? It will impose too much governmental control, especially when it comes to speech. And since you asked for my personal view or interpretation, I think I'm somewhat in between those two extremes. I think it's very important to be ambitious and to have high expectations, but I think it's also important to recognize any potential risks or gaps that the DSA has. I think by itself, the DSA will not solve all of the internet's problems, certainly not all of society's ills, that's for sure. But I also don't think that by itself it will destroy freedom of expression. Yeah, because I think there are safeguards, there are checks and balances in place. For example, the commission can't just go around making actual content moderation rules. It shouldn't, in my view. So I think between these two extremes, I think will be very important to navigate for users, for platforms, for civil society, for researchers, but also for regulators, like dealing with these expectations and these various views on the DSA, and kind of making very clear what the DSA can do and what it cannot do. I think this will be very important going forward.
Thank you so much, Julian. I think that was a great intro. And speaking of what the DSA can and can't do, Athina, could you maybe, in your words, I mean, there's been a lot of talk of what the Commission does within the DSA. And I think the Commission is probably the most known entity at this stage. But for the audience, I think it's helpful actually to recap what is the role of the Commission within the DSA structure. And we've also seen, of course, a lot of resourcing that the Commission is expanding their resources. Could you also speak to that and to how the Commission has already been dealing with the DSA and how they plan to sort of expand that in the coming months?
Sure, with pleasure. And thanks a lot for having me in the panel today. So far, we had quite a few milestones. The Commission side, where we have received the first risk assessment reports from the first designated VLOPs in the end of August. And 2 months later, we have also these designated VLOPs have published their first transparency reports. While we are analyzing all this data submitted to the Commission, but also publicly published by the VLOPs, we are already starting to see where we should put our efforts, where we see some gaps, where we should really ask additional questions to the regulated entities. And that's how we have sent until now, I think, more than 30 requests for information to the designated VLOPs on areas related to protection of minors, advertising, recommender systems, marketplaces. So it's a quite big variety of issues that we are looking into. And where we have a suspicion that there might be some instances of non-compliance, then the Commission so far has gone ahead and sent requests for information. Then we have also opened formally 2 investigations, one before the end of 2023 and one this week, for 2 platforms which are quite different in nature, and there are different grievances that we have in these two opening decisions, but they give a quite good overview or summary of where we are focusing our enforcement actions so far. Now, it is important also to mention that before the end of 2023, we also designated 3 additional very large online platforms, which are more in the area of adult content, and for which the obligations which are for very large online platforms will kick in 4 months after their designation. So we are talking about April 2024. These are the actions that we have been taking on the enforcement side. At the same time, we are also working more on the policy development side, where we have been working on some delegated and implementing acts. The most recent one is the implementing act on transparency reporting templates, with which we will set harmonized rules for all online platforms on how to publicly report according to the DSA. Now, when it comes to the resources of the team, we are growing every day almost. So far, we have been about 75 people working on the DSA, but in the course of 2024, we will grow to more than 120 people working on the DSA. And we have recently closed 2 calls for expression of interest working with us, where we are looking for people with diverse backgrounds, ranging from legal officers to policy specialists, data scientists, more administrative staff, so that we can make sure that we can really do our work and to be able to live up to the expectations of the European citizens.
Thanks so much. Thanks so much, Athina. And I think we heard a little bit about a lot of things that the Commission has already been doing. And this was pre-DSA Live for everyone else. And I think now it sets the stage for the new entities in this space, digital services coordinators that are now can be in full force and can start with their enforcement procedures and their preparations. And I think, Benôit, turning to you, you had a meeting with the digital services coordinators on Monday. So the board met for the first time already on Monday, just, the first working day after the DSA go live date. I'm curious to hear how did that go? How do you see the experience with other digital services coordinators? How will you be working together? And also maybe a little bit about your role within France. How will you be working in France?
Thank you very much, Agne, and thank you to Tremau and to TSPA for inviting us today to speak in this panel. Well, I guess Saturday was a symbolic date, of course. Whole DSA is now applicable. Monday also was a symbolic date. We had for the first time a full board meeting chaired by the Commission. All the DSC were around the table. Some of them are already officially DSC, meaning the process to appoint them is finished. The law designating the DSC, giving them the independence, have been voted in several countries. But still, in a lot of countries, we know who is a DSC. That's the case in France. It's ARCOM. We are the legitimate DSC, but we don't have yet, as I say, our birth certificate. The law is not finished and not finished its process in Parliament. But at the same time, we have started working on the DS implementation for several months. You remember that in November, following the Gaza crisis, Israel-Gaza crisis, the Commission asked member states to designate immediately the DSC and to get them to go in a prefiguration mode. So we are already very actively engaged. And the basic process is that basically all DSCs have started reaching out to companies, platforms which are established in each member state through trade unions, business association, to start the discussion, to receive the question, very practical question from companies that any company may have to understand how to implement the DSA. And we have started the process of explaining when we have a direct answer and to work together as a network, because there is only one DSA. We have a network of regulators, but there is only one policy, and we are really motivated to have a very cohesive and coherent implementation of the DSA. So I guess we are going back and forth, discussing on a national basis, going back to the EU level, going back to the national level, and we will continue doing that for the first year, I suspect. To address your question in France, well, basically, we look, I guess most DSC will have the same dimension. First, we are part of the regulation of the VLOPs. We are not in charge of the enforcement. The enforcement is either in the hand of the Commission for the VLOP specific obligation of the DSC of establishment, and we don't have any VLOP in France, but all VLOPs participate in the monitoring of the VLOPs obligation. We have received the first request from the Commission that was mentioned, maybe to help them gather evidence of potential non-compliance, and it's important to make the difference. I guess it was said very clearly by Rita Wiesenbeck last week. There's a difference between opinions on whether the platform are complying or not, on providing evidence. Clearly, we are in the business of providing evidence. DSA is a fact, is based on fact, and that's how we are going to operate. So that's the first of, I guess, any DSA. Second one, of course, is to be responsible for the enforcement for platform established in our member state, or for platform who have selected to have legal representation in our member state. And here we will do the go-between to help kickstarting the implementation and, if need be, enforce the DSA. The last function, I guess, is really important, is acting as a coordinator. That's how we are named in the DSA, meaning reaching out to all parties in the member state, from political authorities, administrative authorities, NGOs, academics, companies, of course, to get them to understand how they can benefit from the DSA. So to give an example, in France, we have started a discussion with unions representing intellectual property right holders, who are, of course, interested to understand how the DSA will help them defend their intellectual property rights as far as the platform are concerned.
Thanks so much, Benôit. This is was a very useful overview of what the digital service coordinator's role will be. I think you mentioned also VLOPs, and I think that's an important point, that it's, you know, each and every member state will probably be curious, especially on VLOPs that have a significant impact within their territory, given the population size that is using these platforms. I do wanted to, because there's been so much talk around VLOPs and enforcement of VLOPs and sort of how they comply. I did want to ask you if you think that smaller players can sort of relax a little bit or with their compliance efforts, or do you think that they should still remain vigilant, given that the digital services coordinators will also be knocking on their doors?
No, clearly. I guess the DSA is a quiet revolution. Quiet in a sense, or continuous, because DSA is e-commerce in a way enhanced. Under e-commerce, any platform had to be accountable, had to act on a notice, had a limited liability regime. It strengthens with the DSA, but with the DSA, coming together with this limited liabilities, there is also reporting. So the reporting is really the revolution, and it started on last Saturday. Whatever Trust and Safety Department for smaller platform will be doing from now on will have to be accounted for through the transparency report at the end of the year. And then the discussion will start, of course. Some people, some third party may come to the DSC and say, well, that doesn't match with what I'm seeing with that platform. So the discussion will start, and it will come smoothly, but every year, I guess, it will be more stringent, more assertive. And of course, if platforms in the short term are facing real difficulties in operating their business, yes, they may have contact with the DSC sooner than before the end of the year. And it would be even a good idea for this platform, in fact, to reach out to the DSC if they are facing real difficulties to start the discussion on a voluntary basis.
Thank you so much, Benôit. I think this is very helpful, and also for if anyone's from a smaller platform listening to this, in terms of get to know your digital services coordinator. If you don't know who your digital services coordinator is, we published a blog which has a tracker of all digital services coordinators, so that can just be helpful in looking them up. So get to know your digital service coordinator is sort of an action item to take away in case you already don't know them. But Julian, I mean, speaking of digital services coordinators, we have Benôit here, but you've been following, of course, also in Germany, the implementation there, and also across different countries. Do you anticipate some variation at national level on how digital services coordinators will interpret the DSA and approach the DSA?
Yeah, I think so. I think that's to be expected. I think, first of all, there will be variation just based on the very fact that the digital service coordinators in the 27 member states will not all come from the same same regulatory field. Some member states have nominated more like the competition authority. Some have nominated their media regulators. Some of them their consumer protection agencies. Some of them are converged, and it's all of that together. So I think that in and of itself will lead to some variation in how the DSA is approached. But I think there will also be some just variation on interpretations based on national law and national circumstances in those areas where the DSA allows that, right? Because it has to be remembered that the DSA is binding in its entirety. But I think it's also good that there's variation. Like member states should try different approaches to set up communication channels with smaller platforms, to stick with that example that you just talked about, or to adapt to local circumstances when it comes to their platforms. That being said, considering all this variation that's good and necessary, I also think it's necessary to have that collaboration, to share good and bad practices, to make sure that there are some joint efforts in standardization across the member states when it comes to, for example, applications for trusted flaggers or data access requests, that there is some sort of base level of collaboration across the EU. And so consumers, but also platforms, have the security of knowing, oh, the way it's being interpreted here is also the way it's being interpreted there. And there's no forum shopping, neither for consumers nor for platforms. So yeah, to summarize that, yes, some variation is good and will and should happen, but at the same time, collaboration and some joint efforts are necessary.
Thanks so much, Julian. I think that's a really interesting point. I mean, it's 27 different approaches fundamentally, and you'll see on the tracker as well, the background of the different regulators is from a different spaces, and of course, different practices will come across this. But speaking of how to then not have too much variation and avoid uneven enforcement, Athina, can you speak a little bit about how the Commission will work with various regulators, and whether the Commission is also going to facilitate guidance in the area, for example, trusted flaggers or out-of-court dispute settlement bodies?
Yes, absolutely. Maybe just to give you a little bit of background and how the DSA started. One of the goals of the DSA was primarily to prevent fragmentation in the online cross-border environment. So one of the fundamental goals of the DSA is to give the same level of protection to all European citizens, regardless of where the platforms are established and how active the DSC of establishment is. And this is a goal that we would like really to now materialize in collaboration, of course, with the board. And in addition to the board, we had the first meeting on Monday, as Benôit said. We also have other cooperation structures with the member states. We have the expert group meetings. We have the committee, the Digital Services Committee meetings, where the Commission brings several topics to these formations, and we discuss, and we also gather the views of all member states, with the goal of having a common interpretation of how the DSA should be applied across the European Union. Now, of course, we also, I need to mention that in the context of the board, we might also consider establishing more specialized groups. For instance, we have now an ongoing task force on age assurance, where DSCs, representatives from all DSCs are discussing and are giving their ideas on how we can we can standardize and we can take forward these provisions of the DSA. Now, when it comes to guidance and to secondary legislation, it is true that we are looking into areas where it would be beneficial for member states, but also for providers to have common rules and to have the interpretation of the Commission on how to enforce certain rules. Here, of course, the DSA provides for many areas where guidelines are possible, or secondary legislation. We have to prioritize. And you might have seen that earlier in January, or I think it was beginning of February, we issued for public consultation some guidelines on risks related to electoral processes. So this is an ongoing area where we think that 2024 will be quite important year, and that's why we now put forward some our first views about these guidelines. And of course, we will also discuss and get the views of the DSCs and member states on this effort. And similarly, we might follow up with additional guidelines in 2024.
Thanks so much, Athina. I think this is really, really useful information. It's clear to see that there will be a lot of coordination across the different platforms. And I think this is maybe a good point to point out also the uniqueness actually of the enforcement structure of the DSA, which includes such a strong coordination power from the Commission side, but also, you know, intensive coordination across the digital services coordinators who can sort of do joint investigations, etc. So this is really different compared to what we've seen in GDPR and some of the other legislative efforts in the Commission. Maybe a couple of things which I know are in the minds of some of the people online. We did collect some questions with the kind of help of TSPA on what people would want to hear about. And I turn to you, Benôit, around trusted flaggers. So I think that's the one area which is in the mind of VLOPs and online platforms. You know, when they can expect seeing trusted flaggers being designated, how many are already knocking on your doors, or do you know how many are knocking on the doors of other digital services coordinators? And so sort of when can platforms expect to be subject to having to receive and giving priority to those notices?
Well, I guess, the focus on trusted flaggers is very, very important, and because it's really an instrument that can help in the short term, alleviate the pressure on everybody, in fact, because really, if they are designed correctly, if they are well staffed, an instrument to deal with emergency cases which require immediate action. And it's a win-win both for the end users, the citizen of the EU, and for the platform, because it's always tricky to know where the emergency you have to deal with, and having intermediaries which have been recognized by regulators, which are also subject to supervision by the regulator, that will be providing those priority signals, is really a benefit to everybody. I guess we have started first. Trusted flaggers pre-existed the DSA in a way the idea was invented by the biggest platform. What we have now is a framework to really expand the scope of trusted flaggers, to allow trusted flaggers to act as to flag content to any platform in an efficient way. It's another example where the Commission will play a role both by harmonizing how we are going to designate and regulate the trusted flaggers, but also they have the capacity over time to issue secondary legislation to make sure that even from a technical point of view, we can send signaling to any platform efficiently, and that platform efficiently can receive signaling from all trusted flaggers across Europe. So it's really a very important instrument to demonstrate the value of the DSA moving forward in each of our countries. At this point, we have started discussing together. It's interesting, even before the Monday's meeting with the Commission, all the DSCs saying, where do we need guidance? Where do we have to be more precise? What can be done? How can we finance the trusted flaggers? Because as you look at it, it's a cost center, so you need to find some financing. We have to make sure they are independent, but we will be happy to make sure that they're independent, but still they can receive some money from the industry. You can do both together. So then I guess next thing maybe we will be, but I let the Commission maybe elaborate on that to see when we will have sorry, I can't remember if it's an implementing act or delegated act, but from the Commission on trusted flaggers. And then it will depend when the digital service coordinator has the legal capacity to designate the trusted flaggers. In our case in France, as we don't have yet the laws finalized and published, of course, we cannot start the process officially. Doesn't mean we cannot start discussing with entities which want to apply, and we are already having a very active dialogue, both at national level, and we are trying to organize, in fact, a global discussion involving all DSCs and all interested parties to recognize where is the gray area, where we need to shed more light, what are the questions. For example, we have an interesting question: how do we relate with intellectual property right holders, which of course have high expectation, where in this dialogue we're clarifying with them that we do expect that the main tool for them will still be the notice and takedown, but with a very enhanced accountability regime deriving from the transparency report that will make that will be a game changer to assess whether, when we have insatisfaction between an IP right holder on a platform, how can we solve the issue? Who should improve? Is it the IP holder who should improve the quality of the signaling? Is it the platform who should be more reactive? That's the kind of thing we'll have the capacity to deal with the regime, even on the side of the trusted flaggers.
That's really important, and I think there's a lot of nuances to the trusted flagger and the application of that. And I think it's really welcome to hear that there is coordination across member states. I think the Irish regulator has also published some guidance on how they plan to implement trusted flagger provisions themselves. So welcome to look also into that for those who are more interested. Maybe I also see some questions already in the Q&A, and actually my next question to Athina would sort of cover two of those questions as well. So one relates to the transparency reporting delegated act and the guidance that came out there. If you can maybe give a little bit of insight into when can we expect that to go live, or how much changes could we expect to happen compared to what was published now? I know you received a lot of feedback on that as well, and you're probably still digesting some of it. And the second goes around risk assessments. So around guidance on risk assessments, and I think one of the areas there is you gave out a guidance on elections, and I was also asking for feedback there. But I think one of the questions in the Q&A is also how if the Commission plans, sort of probably similarly to Ofcom, define more methodologies and structural indicators around risk assessments and to evaluate the risk mitigation practices. And sort of how to balance the fact that, maybe companies are sort of conducting void risk assessments, relying on their own metrics and not really providing, and the collaboration with CSO is weaker. So maybe if you can, I know these are both really sort of depth of topics, but if you can shed some light on those two.
Yes, sure. So on the Implementing Act on transparency reporting, indeed the consultation closed in the end of January. We received a little bit less than 80 responses to the consultation, which were quite lengthy. So we are still now analyzing the responses, and after that we will revise the text, and which will go then to the committee for consultation and voting with the member states, and then it will be adopted by the Commission. Still, the plan is in Q1 2024. So it should happen in the coming month. I mean, we are in the process of finalizing, and then, as I described, we will consult the member states. Now we have received quite a few feedback from both companies and individuals, business associations, which are publicly available in our website in Have Your Say, and they pertain to topics such as the categories of illegal content, how broad or how limited they should be. They ask also for more clarifications on the templates that the Commission has put in place. And we are really now going through all of this. It is hard for me to say how much the text will change. There will be changes because exactly that's the purpose of the public consultation. Some of them might be more like radical than other smaller changes, but of course everything will be within the legal boundaries of what the DSA provides. So this is, and once the act is adopted, then it will enter into force, and then we will have the harmonized templates and the harmonized periods, so that then the data also that we will be receiving and we will be seeing publicly will be more comparable, because this is one of the issues that we noticed in the first round of reports, where we saw that companies were really reporting on different periods, different data, and it was not easy to compare the data. Now on the potential guidelines for risk assessments. Well, we have seen now the first round of risk assessment reports. It's true that they were not homogeneous. We have noticed differences between the companies. Some are more good examples, some other less so. And we are looking into the possibilities of potentially providing guidance if there is appetite for this. But at this point, there is no decision yet taken on whether we will issue the guidance, and if so, when. Because now the second also round of risk assessment reports is approaching. Companies are already working on these reports. So we would need to see a little bit also the timeline. But this is an area that we are really following very closely. Many of our requests for information so far have been based on information provided in the risk assessment reports. So I can say that we are really scrutinizing these reports, and if we see that there is a need for further guidance, we will do so.
Thanks so much, Athina. I think that's clarifies things as much as possible at this stage, given that decisions have not been made in terms of the specific guidance. I think I turn to Julian a little bit, and I'm gonna do it two ways. I'm gonna ask you one question also from the chat, and one a little bit more. Just maybe as you've looked at the DSA and the implementation of the DSA in a more horizontal manner across different countries and across different platforms, any sort of indications from your side on the first round of transparency reports, and maybe what smaller companies potentially would be looking out for as a result of what we've seeing from the bigger companies' first transparency reports?
Yeah, I mean, but there's also a question, I think, for a lot of the people here that I would be curious about, just first experiences or insights on the transparency reports. From my point of view, I think they're definitely positive things, and you can see that this is a lot of effort for the companies. Some maybe put more in than others, but in general, you know, the transparency reports are there. They were filed. There's data available, quantitative and qualitative. There's probably also data available that wouldn't have been available if it weren't for the DSA. So I think that's also a positive outcome already. But as was already mentioned, I think improvements are still possible when it comes to improving the comparability, maybe getting to a little bit more granular details on user notices, human training of staff, stuff like that. So I think there's probably stuff to be learned, both in the good ways and in bad ways from this first round. And again, my earlier point is this idea of like expectation management. This is the first round. I think the expectation to assume that everything was going to be perfect is probably a bit too much. But I think we, as outside observers, I would count myself as that. I think it is fine to demand from regulators and from platforms to improve each way. But not push them to do that, you know, from one day to the next. Like, I understand that that's way too much to ask. So I think it is a promising first step. I think there's a lot to learn from it. And it's really important that these reports are not just there for the sake of being there. So, you know, transparency for transparency's sake doesn't help either the platforms or the regulators or ultimately the consumer. So it's really important that the reports are there, they are being read, and they're being used to actually make improvements. So to have the report is great, but something needs to happen with those. And I'm just hopeful, I guess, if you want to be optimistic, that the Commission and the national regulators will have the expertise, the staff to do that, because if that is left solely to the platforms, solely to civil society and academia, I think it would just be too much. There needs to be a good like collaboration on dealing with the results from the transparency reports.
Thanks a lot. I think that's a really important point, and maybe actually that's also a little bit maybe back to Benôit on this one. So just looking at and I think then we'll move also into Q&A. So anyone who hasn't really got a question in yet, please do so. But Benôit, before that, this is year one for many online services that have now joined the DSA party. This is also year one for digital services coordinators. So when you're looking at your year one, what are you prioritizing, and also potentially, you know, how are you resourcing your teams in order to fulfill sort of the DSA vision?
Well, I guess at this point, we are really in a mode where we need to establish a baseline, both at the regulators level and with the companies, with the platform. Because it's one thing to negotiate the text at the EU level, it's another thing to implement it, and very strong dialogue has to take place. So as we speak, we are really asking our staff to switch gear every day, going to the EU gear, to have a joint reading, reach out to the companies, and continue doing that. We are open-minded at this point. We recognize that initially some point will not be completely clear and will be clarified in the future. Well, that's the value added of regulators. You can build a relationship with a regulator. Of course, you have to be credible, and it's a repeated game. So we hear, we see, and we see whether the company are implementing in good faith the regulation. But that's basically where we stand at this point, and we are really open to recognizing that we will build the skills which are needed by working with a platform. So that's typically how we start the meeting, saying, okay, you have read the DSA. What are the questions that you have? Where do you think it's clear? Where do you think it's not clear? Because DSA, you could look at it as it's a framework to organize the credibility, the accountability of the trust and safety family. Trust and safety is now had more than 10 to 15 years of existence. DSA is a framework to organize that trust and safety operation are going higher in managing the risk, in quality, in demonstrating the value. And initially it was said typically that some people are afraid that the DSA will harm the freedom of speech. No, I don't think so. The DSA is both focusing on whether too much speech maybe is taken down or too little. We don't know. DSA is here to shed lights and to professionalize the trust and safety operation. And I think it's a real opportunity for people working in trust and safety. And you will teach us some things because you are doing trust and safety. We don't. So we learn from the companies.
That's really well put, Benôit. Maybe I just quickly follow up on one of the questions in the Q&A, which relates to issues of non-compliance and complaints that are open against these companies. So, and I think one of them would be if these are visible to the general public. I think that really depends on whether they have become public by other means. But I mean, from the regulator side, maybe you can comment on that. And how long would a company have to resolve these issues, right? From your perspective, if you can just comment on that.
I guess that per se in the process there is no publicity organized, but experience demonstrates that when you have a significant complaint, it means that you have a real issue, and usually real issues cannot be hidden very long. So at the end of the day, it's public in most cases when it's serious. It's not public when it's limited non-compliance. After that, how long do you have to solve it? There is no general rule. It's completely different whether it's something. The DSA is really has a philosophy which is very clear, which is different from what we have seen in other regulation. It's risk-based. If you have a major risk and the non-compliance relates to this major risk, yes, you will have a huge pressure to fix it very fast. If the non-compliance is a consequence, it can be established because yesterday a delegated act was published. Clearly, this is going to be taken into account. And at the end of the day, it's a dialogue. That's what regulation is about. I always mention that. The objective of regulation, the objective of the DSA is to get compliance, is not to harm the industry. It's not to collect fines. We may have to do that if need be, but that's not the objective. The objective is to get compliance and to improve the situation for everybody and to help the industry develop itself also at the same time while protecting the fundamental rights of citizens.
Thanks so much, Benôit. I think that was very, very clear. Athina, turning to you, I have two important questions for you. And one of them, I'm really looking forward to getting a proper answer out there because I think there's a lot of misinformation out there on that one. But in terms of, so first turning on the risk assessments or on investigations open on compliance. So I think the question speaks to the evidence base, given that there's the risk management framework is very new. The provisions on data access aren't really properly live yet, barring sort of one provision. The first round of audits hasn't been yet sort of completed. So what is the type of evidence that the investigations would be building on in this moment? If you can share anything on that, that would be helpful. And another question from the audience, which is on will the code of practice on disinformation become a legal obligation for VLOPs under the DSA?
So if I start with the first one, in general, I cannot really comment on the ongoing investigations. What we are assessing, which is the compliance with, as the question asks, is the compliance with Article 34 and 35, in addition to some other grievances in these two opening decisions. So for 34, we are assessing whether the companies have diligently assessed their risks, and whether on the basis of this risk assessment they have taken appropriate, reasonable, and effective mitigation measures. The audit reports and the data access, Article 40, are not the only sources of evidence that we can have. There are also many other areas. Article 40(12), for instance, is already in place and effective. There is a lot of research out there for risks related to these two platforms. As Benôit said also in the beginning, we are also working closely and together with member states. So there are sources of evidence. And I think I will leave it at that point. But one important thing that I want to say is that the opening of an investigation does not mean that we have concluded that there is a breach of the obligations under the TSA. We are in an investigation phase, and if we conclude that there is a breach, then there are follow-up actions that we will take. But we are not there yet. And there is no also timeline for this. We will see how long it takes. We will take our time to do this properly. But we are not working under any strict timeline that we need to deliver something by a specific date. So this should be clear. Now, the second question on the code of disinformation. So there is Article 45 in the DSA, which is about the codes of conduct, where the Commission and the board may encourage also the setting up of codes with specific focus on certain areas of illegal content or specific risks. The code on disinformation, similarly also to the code on hate speech, are these such pre-existing codes which could become codes under the DSA, which means that the Commission would need to take into account the participation of a company into the code when assessing compliance by this company. However, there is a process for this to be done, and the board should be involved in this process. And if the code comply with the requirements under Article 45, then it could become a DSA code of conduct. But at this point, since we haven't yet started any official consultation also with the board, it's we cannot definitely say that it will become, but I think we all see this as a potential outcome. And also just to say that in the guidelines that in the public consultation of the guidelines for elections that we published, we have taken a lot of inspiration from the code on disinformation and the commitments that there are there. So of course we are already using all the work that has been done on specific areas of content or risks, and we are now bringing everything under the umbrella of the DSA.
Thank you so much, Athina. I think there was a really, really helpful clarification also for the first question, and I think really, really useful to hear on that as well. For the second question, I just have one quick follow-up. Because I think does this mean that the code of practice on this information would become legally enforceable as like an obligation under the DSA, or would it still remain voluntary, just part of the DSA, subject to monitoring obligations by the Commission, the board, and KPIs?
So if the code becomes a code under the DSA, the participation of a company into this code will be taken into account when we assess compliance. Also under Article 75, the Commission could, the platform would need to put in place an action plan for the compliance with the certain obligations, and the participation in a code could be part of this action plan. However, how this practically will work, we still have to see. It doesn't mean that adherence to a code means automatically compliance with the DSA. I think this is pretty clear. But we would need to see on a case-by-case basis what exactly means the participation of a certain company in a code.
Thank you so much, Athina. That's very helpful. We are running very quickly out of time, but maybe just one question back to Julian again on does each country have a unique regulatory body to handle complaints made by the public? I think maybe this is a helpful moment to just recap Article 53 and that what avenues that will open for users between the communication between users and digital services coordinators. Can you just give us a quick recap on that?
To me, it's one of the more complicated practical things in practice. So I'm not sure if we can figure that out in the last couple of minutes. But I do want to try at least to say that I think it's very important to differentiate between complaints about individual pieces of content that might be illegal under law or under platform terms of services, and potential breaches of the DSA. For example, there is no reporting mechanism in the first place, or ads are not being made transparent, or the ad archive doesn't work. The line is not absolutely clear. It is blurry. I understand that. But I think these differentiations will play out differently in the member states. And I hope that somewhat answers the question. Some DSCs will handle both individual pieces of content complaint and DSA breaches, but some DSCs will not do that. And they will forward complaints about individual pieces of content, let's say, to a media regulator or to a court. So I think that's one of the things where there might be some variation in the member states, as far as I can understand it at this point in time.
Fantastic. Thank you so much. We're 1 minute out of time. I would have loved to give you some words of conclusion, but I'm afraid I think we can't do that. Some of the questions also remained unanswered, but we can try and take those offline to some of the people, and TSPA is so kindly usually facilitates that. All I want to say is I really thank you so much, everyone, for joining. Thank you for listening to us. Thank you for the panelists for making their time available for us. I think this was a really insightful discussion. I think it's going to be a really interesting year for everyone here. And I think just to reflect on what Benôit has said, this is going to be an ongoing conversation. There is a lot from everyone's side to learn here. And this is just the start of this sort of entangled relationship that we find ourselves in, which we call overarchingly the DSA.
Yes, and I just want to say a big thank you to you, Agne and Tremau, for partnering with us to put this together. I think this was a really valuable discussion for everyone who attended, and very clear that there might be a part 2 in the second half of the year. So thank you all for joining us, and yeah, we'll close it out here.